Well, we do have about 10-15 minutes for questions. I might kick off in relation to the national profession reforms. I welcome your call to say that you'll provide assistance as necessary. I wonder, I think the view among a number of the law societies is we do need to get the legislation in Victoria and New South Wales to show that the model can work, that it won't increase the cost of regulation. And I wondered if you could comment on the ability of the Commonwealth to provide some seed funding to get that going.
Should have been a tighter question, Rainer. The Commonwealth's got plenty of ability to provide seed funding. The question is whether we will. My predecessor, but one, Robert McClelland, said that there was $1.7 million back in 2010 to support the introduction of the National Legal Profession Reform. That was at a time when the three Eastern Seaboard states and the Northern Territory were participating. As I've said to the State and Territory Attorneys General, just as I've said to you, the Commonwealth's ready to assist. Whether in these currently straitened fiscal times there will be $1.7 million available. Finance tend to go around hoovering up that kind of loose bits of money. I'm not sure, but I'm waiting to see the bill from the State of Victoria and the State of New South Wales, both of whom have promised me that they will be legislating for their part of the reform as the seed of a uniform scheme before June 30th, and I'll have another look at it then. But the Commonwealth's commitment to this remains. Even if there might not be $1.7 million, there will be some.
Okay, there's roving microphones available if anyone would like to ask questions. Yes, Dan.
Mark, one of the unforeseen consequences of the national scheme or the move towards it is the funding of Supreme Court Library, which is a library available to all practitioners. Has the federal government considered if there's an opening or an ability to pick up the shortfall in some way?
I'm not aware of the particular feature there to do with Supreme Court libraries. The concern that's been expressed about this national legal profession reform is very much that local practitioners, particularly those that don't have interstate or international practices or don't have any international clients, say, what's in it for me? Why should I bear any additional cost at all? And that's why the Commonwealth stood ready to assist at the commencement of the scheme, and I'm very much aware of that being the problem, that there's not much incentive for local practitioners to participate if it's going to cause them additional cost. So I'm happy to look at it some more.
Thank you for your speech, Attorney General. Simon Brenny from the Institute of Public Affairs. You spoke about Conservative governments at the state level passing law and order reforms which you're not happy with. And I would agree with you, particularly in the sense that particular governments have been removing fundamental legal rights, and probably the most obvious example of that was 2 weeks ago when the New South Wales Parliament unfortunately passed a law which, to a large extent, removed the right to silence. However, tomorrow at COAG, one of the things that will be discussed is some reforms to anti-gang law, and one of the particular aspects of that package is to do with unexplained wealth laws, which reverse the burden of proof. You're in favour of these laws, and I was wondering if you could explain why it is that fundamental legal rights removed at the state level is not acceptable, but removing them at the Commonwealth level in relation to unexplained wealth laws is acceptable.
I think you've got a bit of a mixture of concepts there, Simon, but just to pause on the New South Wales laws that you've referred to, which is a removal in a limited way. I wouldn't say it's a complete removal of the right to silence, but it makes possible a range of judicial charging about the conduct of the defence case. And the significance of it in the context of my remarks earlier about Conservative government changes badged up as law and order is that they impose costs on the legal assistance sector. And this is an example of it. the particular way in which that New South Wales law works is to impose very substantial additional work on Defence Counsel, because the legislation specifically refers to cautions that have to be given, preparatory work that has to be done by Defence Counsel as part of that, as I say, partial removal of the right to silence. The unexplained wealth laws are laws that we think are necessary on a national level. At the moment, we're faced with rejection from most of the states, and that's something that's going to be further discussed at COAG tomorrow. The reason why the Prime Minister has raised it up to COAG for discussion with First Ministers is because the Standing Council on Law and Justice, which is where the Attorney-Generals meet as part of the cooperative system, has failed to reach agreement on this despite 2 attempts at the 2 meetings of the Standing Council last year. And the Prime Minister and I thought that it was appropriate to have it discussed at COAG because we think there's a need for there to be unexplained wealth laws. Unexplained wealth laws, for those that don't practice in the criminal area, are laws that would dovetail with proceeds of crime laws that we already have, which enable courts to proceeds of crime laws, of course, make it possible for courts to order confiscation of property from people who have been convicted. Unexplained wealth laws do not require a conviction and do require that state or federal authorities choosing to bring that kind of proceeding, and some states already have unexplained wealth laws, are able to go to a court to seek an order for confiscation of property. And I would prefer to think of it as a shifting onus rather than a complete reverse onus. They're laws that are needed, we think, to deal with people who are involved in usually organised crime at a very substantial level, who have acquired very, very substantial assets. This makes possible, but they are people very often, and this is what the law enforcement authorities have repeatedly said to the Commonwealth Government and to state governments, the people who are hypothetically the subject of this kind of unexplained wealth proceeding are people who have distanced themselves from criminal activity. They are several levels above the street, several levels above the actual commission of a crime. And I think that the time has come, this is why the Prime Minister is raising it with First Ministers tomorrow, for there to be a national scheme, not just a very piecemeal scheme, that enables criminals who do cross state boundaries or territory boundaries to set up operations or take their assets to jurisdictions which have no such laws. We think it's appropriate that there be a national law. And Simon will probably be thinking I haven't really answered his question, but I don't think that there is a proper comparison between removal of the right to silence and your description of these unexplained wealth laws as a removal of the or a reversal of the onus of proof. I think you have to look at what is proposed here and the way in which those unexplained wealth laws work. I can't believe we're out of questions.
Well, I might ask another question, which is in relation to family law, which is obviously a Commonwealth responsibility. We're seeing in Victoria, in parenting disputes, no funding provided for when you get to court. So there's funding provided for preparation for court, but when you get to court, people are left to be self-represented, and that can be in situations where they're dealing with situations of family violence, abuse of children, and so forth. And I wondered what the Commonwealth response to that situation is, because it's playing out every day in our courts and it's a real issue.
I can assure Rainer, I can assure all of you that the Commonwealth understands this particular problem. It's been raised with me constantly. It's up to individual legal aid commissions to allocate what is scarce funding in the way in which they see as appropriate. I've met with Bevan Warner, the head of Victoria Legal Aid, discussed this precise problem. There's a degree of preference given to the appointment of independent children's advocates by Victoria Legal Aid in preference to appointing lawyers for both parties to the dispute as well as the independent children's advocate. Sometimes you'll just get the independent advocate. And I think until such time as there is more funding for family law matters, you're going to continue to see that kind of rationing, which is an inevitable result of the amount of money that's available. I can't, as such, direct Victoria Legal Aid or any other legal aid commission as to precisely how they are to spend the funds that they're provided with by the Victorian or other state and territory governments and the Commonwealth. What I can do is look at it closely, and one of the outcomes, I hope, of this review of the National Partnership Agreement is going to be that we will be provided with a bit more hard data on just how legal assistance is working, where our legal aid dollars are going, and that may provide a better basis for making decisions in the future. But inevitably, it's always been so, and it'll probably continue to be so. You're going to get these rationing decisions, which will mean that often very worthy cases, very deserving cases, are not receiving what you would hope would be the level of representation that they should have. And any of you who practice in the family court know very well the problem that unrepresented litigants produce in litigation in the family court. It's something that the judges of the family court have left me in no doubt about, from the Chief Justice to other judges on the family court who've spoken to me about this. They would wish to see better levels of representation for litigants in their court. Federal Magistrates Court, now called the Federal Circuit Court of Australia, exactly the same. They too have a great deal more time taken up than might otherwise be the case because they've got unrepresented litigants.
One final question.
Singing. We've had one episode of singing during my term in Parliament, which was the former Senator Mary Jo Fisher, who gave us, some of you may recall, a rendition, not a very good one, of the Hokey Pokey. I wouldn't encourage it, I'd have to say, given the way I've heard some of my colleagues sing, and I can't recall a single example of people singing in the House of Representatives. Peter Garrett is often encouraged by the opposition mostly to perform various songs, and mercifully Craig Emerson has refrained from, he's sung at press conferences, but he's refrained from singing in the chamber of the House of Representatives. And I'd say again, and I hope my colleagues can hear this, I wouldn't be encouraging it.
Thank you.